Hi everyone, in this week's dispatch video we are continuing with the theme of conduct outside of work and when that can impact on the employment relationship. This time we're focusing specifically on cases with a criminal element, and the starting point is to make it clear that simply because somebody is being investigated for, charged with, or is being convicted of a criminal offence, it does not automatically mean that there is a right to dismiss. The ACAS Code of Practice, which employers are obliged to follow, states that if an employee is charged with or convicted of a criminal offence, this is not normally in itself reason for disciplinary action. Consideration needs to be given to what effect the charge or conviction has on the employee's suitability to do the job and their relationship with the employer, work colleagues and customers. So similarly to what we discussed previously with employees who carry out certain acts which are not criminal outside of work, or social media cases that we've also looked at, what is the impact on the employment relationship or the business? So firstly, we look at the investigation stage. One question that has arisen in cases in the past is whether or not the employer can rely solely on police investigations, and the general consensus is that they can. And that is sometimes difficult because finding out the evidence that the police have gathered can often be quite traumatic for employers, and indeed the authorities do try and sometimes prevent the employer from carrying out their own investigation so as to not prejudice the criminal element. But there are a couple of cases where it's been made clear that, subject to certain safeguards, an employer can treat information received under an official disclosure regime, such as a police investigation, as reliable. The employer must still take a critical approach to assessing that and resolving any conflicts of evidence. But ultimately, if the foundation to the dismissal is based on police evidence which has been gathered and not necessarily a fresh investigation which has happened internally, the tribunal won't be quick to criticise that. So we come on to the main question surrounding this video, and that is whether I as the employer can dismiss in circumstances where there is a case with a criminal element. Where the offence is related to the employee's employment, it's likely to be a fair dismissal. So, thinking simply theft from the employer, it follows that the employment relationship really can't continue in those circumstances. If the offence is not directly related to the employee's employment, we may still have a fair dismissal if the circumstances of the case reflect on the employer's reputation, or if that act has destroyed trust and confidence. So in the case of Moore and Modes, this is an example of criminal conduct being completely incompatible with the nature of the employee's work. So this is a supervisor at a clothing store who is found guilty of theft from a different clothing store. And the tribunal was very willing to draw the conclusion that a criminal offence committed, albeit not directly on the employer's time in its own store, clearly had a direct impact on employability. And that's a trust and confidence issue as well. How can we have confidence in the employer to carry out their role competently in circumstances where they've been convicted of shoplifting from another retail store? The second case on this nature is Norfolk County Council and Bernard. So this involved the dismissal of a teacher following a conviction for possessing cannabis outside of work. I think the focus in this case was on the fact that this was a school setting, an educational environment, and they had some vulnerable individuals at that school. However, it was an isolated occurrence. The individual didn't actually work with children, they worked with adults at the school, and it wasn't fair to dismiss the employee for that offence. However, a very similar case in a school where an employee did take cannabis and was involved in the teaching of children, that was actually held to be a fair dismissal, so very fact specific there. And finally, we'll look at cases involving reputational risk now. So this is where, again, there is no direct relation between the offence and the working environment, so it wasn't theft committed at work, for example. But in Leach and the Office of Communications, a senior civil servant was dismissed after his employer discovered he was investigated for sexual abuse of a minor. He never accepted the allegations. He was never actually convicted, and there was no direct bearing on the work. But reputational risk was something which could be relied on in this case, I think, given the media attention on the matter, and that was deemed to be a fair dismissal. Now, I would say generally that that is quite a risk that the employer has taken there, because unless they could actually demonstrate some significant reputational damage, especially in circumstances where there was no conviction, and I assume an investigation would not have revealed anything to the employer, I'm not sure a fair dismissal would be judged in each case there. In a separate case, a police officer was convicted of dangerous driving outside of work. That was held to be fair because of the reputational impact, not only externally but internally as well. There were aggravating circumstances, such as the fact that the police officer managed to injure 4 other officers, and there was already a policy in place which required an officer to show why they should not be dismissed if there was a serious traffic conviction applied. So I think that was a case where the consequences and the gravity of the conviction was such that it was fair to dismiss. And the final one was in relation to an employee who was charged with murder, but unsurprisingly protested his innocence. Now, again, this is a publicity case, so there was significant media attention surrounding this. The individual worked for Royal Mail Group, but in addition to that media interest, the one employee said they just would flat out refuse to work with the employee, and they were working together in a critical role. And as part of the bail conditions, the employee was actually prohibited from having contact with another couple of colleagues. So whether or not that case was conduct and or some other substantial reason in terms of him not being able to perform the job because of those limitations, but that was again deemed to be a fair dismissal. So as with all cases we've examined in conduct outside of work, it's too simplistic to say that dismissal should follow as a result. We do need to look at the consequences and the risks to the business of retaining somebody in deciding whether it will be fair or not to dismiss them. If you need any further assistance on these cases, or indeed any other employment matter, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.